following lecture deals with prosecution and defense. The prosecutorial system. Most of us see the district attorney in our county. They're usually in the news, and they usually are on the news when they're dealing with high-profile cases. They're elected for 4-year terms in given districts, and they handle local cases from county and city law enforcement. The Attorney General is a state elected official who also serves a 4-year term. They're the chief legal officer in most states. They have the power to prosecute in certain circumstances, and they do offer legal opinions in cases dealing with the law where it hasn't applied yet, like a case where a new law is instituted and departments want to have some direction on how to enforce it and they haven't arrested anyone yet. We also have the United States Attorney General. They're appointed by the President and approved by Congress. They're in charge of the Justice Department, which handles all federal law enforcement, and they supervise U.S. attorneys who are responsible for the prosecution of crimes that violate federal law. Politics in the prosecution. Well, you know, the DA is an elected official, and they're influenced by public perception and the need to get reelected. High-profile cases are given high priority, and campaign contributors can get special treatment unless they become high profile. This chart basically gives you an idea of the typical actions of the prosecuting attorney in prosecuting a felony case. Starting with investigation and arrest, they assist in the preparation of search warrants and arrest warrants. They receive case files and screen them to determine if the prosecution should proceed, and they also give advice on what evidence is necessary. At the initial appearance, as attorney for the government, they inform the court and the accused of charges, usually seek high bails. They may drop the case by entering what's called nolle prosequi, or decline to prosecute. In the preliminary hearing, they establish prima facie case and evidence, oppose bail reduction, and discuss the case with the defense. At the arraignment, they present charges against the accused through indictment or information and acknowledge the plea that's given by the defendant and continue plea bargaining. In pretrial, they gather evidence for the prosecution. They interview witnesses. They continue to work with the defense and accept plea bargains if they're offered. In trial, they respond in court to the defendant's charge of pleaded guilty by reducing charges or take an adversarial stance in jury selection and prove the state's case beyond reasonable doubt. In the sentencing phase, they recommend and justify the sentence, and in the appeal phase, they prepare the argument to counter the appeal filed by defense. Roles of the prosecutor. They could be the trial counsel for the police. In other words, they reflect a law enforcement view in court, and they also take a crime fighter stance in court. They could be the house counsel for the police, where they give advice so that arrests will hold up. They also are the representative of the court, enforce rules of due process, make sure the police act in accordance with the law, and uphold the rights of the defendants. And they're also elected individuals where they have to respond to community opinion and think about the political ramifications of their actions. Key players that the prosecution depends on include the police because they prepare the case, collect the evidence, and bring the defendant forward. They depend on victim and witnesses because they need their testimony to help do their job. And they depend on judges, and they need to know the past history of judges' decisions, have good relationships with judges, and decide which cases they should plead out and which cases they should go to trial on. I'm going to go over some terminology. First is necessary included offense, and this is an offense committed for the purpose of committing another offense. An example, being armed with a weapon as a charge that would be part of armed robbery, possession of a concealed weapon. A count is each separate offense, charge, and indictment or information. If you've reviewed the CD-ROM in the previous lecture, I asked you to look at the instrument of death video, and that would have explained that. Discovery is a prosecutorial pretrial disclosure to the defense of the facts and the evidence they will use in trial, kind of a list of witnesses and list of evidence. It's not uncommon that the prosecution will ask for pretrial discovery based on what the evidence that's going to be presented by the defense. Nolle prosequi, which we'll talk about a little bit later, says that charges will be dropped or dismissed. Concurrent sentencing is the terms of incarceration run together, meaning that if you get found guilty on a case where you're sentenced to 2 years, 3 years, and 5 years, that you're only going to serve 5 years because the 2 years and 3 years will be within the 5-year term. They all start on the same day. Now, consecutive sentencing says that each term of incarceration is served separately, meaning that if you have 2, 3, and 5 years, then you're going to be spending 10 years in jail. So that's a good tool that prosecutors could use to try to get a plea bargain. A plea bargain, we've talked about this in the last lecture, but the prosecutor works out an arrangement to give consideration if the defendant pleads guilty. The accusatory process is what happens in pretrial, the events that take place from arrest and booking through the filing of formal charges on the defendant. And diversion is an alternative prosecution. Under PC 1000, example would be they'd get treatment for possession of drugs instead of prosecuted. Prosecutorial discretion. The prosecutor has to come up with different systems to determine who they're going to prosecute. The 3 systems we'll review are system sufficiency, trial sufficiency, legal sufficiency. The prosecutor has to also remember that they're responsible to the public for what they do, and that they could be taken out of office if they don't do the right thing. So 3 models that we'll look at. Legal sufficiency model says that if there's the minimum requirements to prosecute the case, that they'll go ahead and prosecute the case. This is usually a district attorney's office that is not very busy, and so therefore they'll go on any case they have legal grounds to do so. Systems efficiency model is something like you'd probably see in Oakland or San Francisco, where 3 factors are reviewed. The caseload of the district attorney's office. Can they get a quick early disposition on the case? Is the evidence adequate, or is it going to take too much time to handle this case? And can a plea bargain be struck to save time and money? Try not to go to trial if possible, because the system's already overloaded. The third model is the trial sufficiency model. This is a person who's kind of sports oriented. You know, they have a win and loss record, and they really want to know, can they get a conviction? Is the evidence strong? If it looks like they can win a case, they'll go for it. If it looks like they can't win a case, they won't even touch it. So what are the options the prosecutor has? Well, they can bring a case to trial, they can dismiss the charges, or they can dismiss the charges anytime using nolle prosequi. Again, factors that influence the prosecutorial decision-making. System factors include the clogging of the system or wasting of time on minor cases when they've got major cases that need attention, or wasting time on a case because it can't be won. Other case factors include the attitude of the victim, the cost of prosecution, because things like DNA are not cheap to get processed, undue harm to the suspect or victim, or alternative sanctions that are appropriate and can be used in the case. This is a slide that basically shows the differences in how prosecutors handle cases in 2 different jurisdictions. You're looking at Golden, Colorado, and Salt Lake City, Utah. And I'll give you a second to review this. This slide basically shows the 3 different models that I showed you, and how, looking at these models, how they do case management. So the first one we're looking at is legal sufficiency model, and you got 100 cases. All have, they have 90 that are sufficient for prosecution, and they go through the process that way. If you look at the next one, system sufficiency, they're only going to charge 70 of those cases, and trial sufficiency, where they think they can win or lose, they only charge 30 of those cases. So there's a big difference in, right from the jump off, from out of the gate, how many cases are going to be charged. Nolle prosequi. You should know this term. It's Latin, and the reasons for nolle prosequi can include, and remember that it is a decision made to decide to drop a case, and it's usually made because the evidence is insufficient, or the witness is reluctant to testify, or the police made a big boo-boo. They made an error in search and seizure or violated somebody's rights, or there's an office policy about what sort of cases they're going to charge. Common reasons for rejecting the prosecution include insufficient evidence, witness problems, the interest of justice, due process problems, the plea on another case, pretrial diversion, or referral for other prosecution. Now, just to give you an example, interest of justice, if someone was to use deadly force to defend themselves and the prosecutor felt that it was justified in the interest of justice, it would not charge the case. What's prosecutorial misbehavior? Well, according to legal expert Stanley Fisher, it's if the prosecutorial excess occurs when the government always seeks the highest charges, or interprets the criminal law expansively, or wins as many convictions as possible, or obtains the most severe punishments. Criticism of prosecuting attorneys can include, and this is the opinion of the author, again, focusing on the use of the office as a political stepping stone rather than the duties of the job, trying to run for another office afterwards, failure to fully investigate some cases and dismissing others, or lastly, bargaining justice away by over-reliance on plea bargaining, being scared to go to court. The next thing we want to talk about is the defense attorney, and their primary role is to advise the defendant at each stage of the prosecutorial process and accusatory processing. Here are typical actions of the defense attorney processing a felony case. At the police station after arrest or during interrogation, they're ensuring constitutional rights are not violated. They're giving advice during interrogation. They're making sure that booking and pre-release and all these things are done, and make sure they determine the facts of the case from the police records. At initial appearance, they appear with the accused before the judge and seek pretrial release if possible and challenge the basis for arrest. At preliminary hearing, they challenge the prosecutor's stand that probable cause exists. They seek bail reduction. They try to discover evidence held by the prosecutor. They counsel the defendant as to the nature of the case and discuss the case with the prosecutor. During the arraignment section or proceeding, they learn about the charges and they advise the defendant on whether or not to plead guilty or not and discuss plea bargaining with the prosecution. Before trial, they try to continue plea negotiations and file pretrial motions challenging evidence of prosecutorial errors. During trial, they change the plea from not guilty to guilty as a result of a bargain, or assume an adversarial stance in jury selection and presentation of the defense. During sentencing, they prepare a client for the expected outcome and urge a lenient sentence. And during the appeal process, they try to develop the appropriate basis for appeal. Primary goals of the defense are to protect the constitutional rights of the defendant, keep the prosecution fair in preparing and presenting the case, and prevent the conviction of an innocent person. There's different ways that people get representation. Obviously, the Constitution says that you have the right to an attorney. We're going to discuss some of those different systems. Indigent means that you don't have any money. So indigent defender systems include public defender system, assigned counsel, contract counsel, and mixed systems. Private attorneys are out there, but they only handle a small percentage of criminal cases. It's usually for the rich. Assigned counsel is where in areas that don't have public defender's office, the judge assigns attorneys registered out of the local bar association. Contract system is where a law firm contracts with the county to handle all indigent cases. Public defender's office is usually run by a public defender who's elected or appointed by county supervisors. They handle about 85% of criminal cases. Little history on public defenders. 1791 Congress passed the Sixth Amendment, guaranteeing a right to speedy trial, impartial jury, and assistance of counsel for the defendant. First public defenders were court appointed. They were expected to serve the public without compensation, and this was a burden to the local bar association. It forced judges to appoint young, inexperienced attorneys, and most of all, their golf buddies didn't get appointed. It was mostly young, inexperienced attorneys that got appointed. At first, the Public Defender's Office was part of legal aid societies that handled both criminal and civil matters, and a lot of them were set up to handle the problems with immigration for new immigrants. We're going to talk about the evolving rights to counsel. Some of the important case decisions included the following listed, which we'll take one by one: Powell, Gideon, Argersinger. Powell versus Alabama. Supreme Court ruled that indigents charged in a state court with a capital offense has the right to the assistance of counsel at trial under due process clause of the 14th Amendment. That was the first one. Next was Gideon versus Wainwright, which said that because Gideon said, hey, I got 7 years for a burglary and I didn't get counsel, and the judge said, well, it wasn't a capital offense, a death penalty offense. Well, he appealed to the Supreme Court, and they stated that an indigent defendant charged in the state court with any non-capital felony has the right to counsel under the 14th Amendment. In Argersinger, it says, any time you have a chance to be imprisoned for any offense, even for 1 day, whether it's a misdemeanor or felony, that you have the right to have counsel. So you see how this progressed. At first, it said that people that don't have money should have counsel on capital offenses. Then it was on felonies, and then lastly, it was on any case where you could be imprisoned, where life or limb was in jeopardy. So in 1962, after the Gideon versus Wainwright case, the burden of the caseload shifted, and legal aid society were replaced with public defenders' offices. The Ford Foundation created the National Defender Project in 1964 and donated over $6 million over 5 years so they could set up public defender systems in over 60 cities across the nation. Problem with the system was it was hard to recruit attorneys because of low pay, and they were understaffed. Now this has changed, especially in Contra Costa County, where our college is situated. The district attorney and the public defenders get paid the same amount of money, so that you have good competition and people will put in for these jobs. There was a study in St. Louis in 1983 that basically showed that they had 12,000 cases and the public defender only had 22 attorneys at a cost of $695,000, where the district attorney had a lot more money to deal with, 45 attorneys with $2.4 million. Now, some people may think that's unfair, but the fact of the matter is the burden of proof is on the district attorney to show that people are guilty. And so they may need the extra manpower or person power to be able to make those cases come to fruition in court. What's the ideal program? Should have adequate staffing and funding to hire experienced attorneys, and it should be effective, efficient, and productive. Another thing that's come up is that in other countries, if you're going to be a judge, judges start as attorneys and they become judges. In other countries, you decide after law school if you're going to be a judge, and if you are, you continue with your educational process. We might want to look at some system like that here in our country. These are your key terms for this lecture. I would pause the movie at this point so that you can write these down, because these are going to be topics for testing. That's the end of this lecture.